Great. Good morning, everyone, and welcome to this talk. It's great to see so many of you here to talk about data protection legislation on a Thursday morning down here at the XL. My name's Chris Combemale. I'm the CEO of the Data and Marketing Association. And for those of you that may not know us, as the UK's leading trade association for progressive marketers, the DMA represents the industry to government, provides a full suite of resources to improve marketing effectiveness, and enables industry relationships through participation in councils, committees, and events. We set, promote, and teach the standards that the industry should live by, and ultimately our code, which is an ethical framework, sits at the heart of everything we do, providing a guide not just for our work, but for the work of the industry. And as you won't be surprised, our main legislative priority in our work with the government is the overall data protection framework. And over the past 2 years, the government has engaged widely with industry to develop the first post-Brexit reforms to data protection legislation, which has resulted in what's called the Data Protection and Digital Information Bill number 2. It's number 2 because number 1 was first tabled last year on September 5th, the first day of the short-lived Liz Truss government, and it was withdrawn that afternoon for further work. But in that period of time, we've actually been able to make significant progress on the legislation that should deliver clarity on key issues to marketers. And our approach throughout the consultation period has reflected how we go about things at the DMA. Everything we do is by the industry, for the industry. And by taking collective feedback from our members and leveraging our relationships with the government, we have achieved important clarifications in the legislation that will enable growth and innovation while maintaining high standards of data protection. And very importantly, the most important thing to our members was to ensure that there was no risk to data adequacy with the EU. And we believe this legislation achieves that balancing act, that balance between innovation, growth, and privacy. Now, we work closely with officials on the initial consultation. Way back on the 7th of October 2021, we held a very large roundtable with our members and the department officials. More recently, in that year, since September 5th, I've chaired a business advisory group for the Secretary of State, Michelle Donnellan, which has included all of the major UK trade associations, so Tech UK, UK Finance, Make UK, even the CBI until they were not welcome anymore after their recent events. And we have made significant progress. I'll start with what the government sees as its objectives in the business. So this is how the government looks at the bill. They want to introduce a clear, business-friendly framework that incorporates the key elements and objectives of GDPR, but provides a bit more flexibility about how you comply. Critically to the work we did on the bill is to provide organizations with greater confidence about when they can process personal data without consent. And that in particular means clarification around legitimate interests and when it can be used for marketing. Clarify safeguards around automated decision-making, strengthen the powers of the ICO's office and redefine their objectives a little bit, unleash more scientific research. I won't talk too much about that, but there are a lot of small tweaks in the legislation that will make it easier in the life science and medical research and other pure scientific research to share data from one study to the other to develop better solutions. And as we speak, the bill is making its way through Parliament, but it's not really new legislation in its own right. What it actually does is update simultaneously 3 existing data protection legislations, the UK GDPR, the Electronic Communications Regulation, and the Data Protection Act 2018. So actually, to understand the legislation, you have to have all three of those open in front of you and go clause by clause, because one clause might be changing one of those, the next one will be changing a different one of those. So basically where we've got to, we got through second reading in Parliament, we've had the committee stage back in May. It went through in record time with pretty good support from across the political spectrum, including quite a lot of support from Labour, Lib Dems, and the SNP. It has been carried forward to the next session of Parliament following the King's speech, and we expect that to be report stage and third reading before going to the House of Lords, with royal assent in spring 2024, and then about 12 months to get ready and implement, although some things will come in immediately and some things will give the ICO time to update their guidance on the legislation. We're going to look very quickly at all these things. I won't take you through the list now. We'll just get right into it. I think one of the important things to start with is legally and legislatively, what is the definition of direct marketing? And to achieve consistency, what the legislation does is it places the same definition in GDPR and PECR as exists in Data Protection 2018. And it's a little broader than what practitioners may think of as direct marketing. So in the legal sense, direct marketing is the communication by whatever means of advertising or marketing materials which is directed to particular individuals. So you'll see immediately that that covers personalized digital advertising as well as the CRM channels that you would normally think about, social media, email, print, telephone. And that's quite important to understand when you're looking at the scope of things like lawful basis for processing. And I think the most significant area we worked on was greater clarity around use of legitimate interests in the legislation. So at present, processing for legitimate interests is one of 6 legal bases in GDPR that are all equal according to the law. And when relying on legitimate interests as a lawful basis, as most of you probably know, organizations must demonstrate the processing is necessary for the legitimate interest and that it carries out a balancing test to weigh up the interest the organization is pursuing against the privacy of their customers or prospects, as the case might be. And I think it's very clear when it comes to direct marketing, you can't do any personalized communication to customers or prospects without processing the personal data. So we meet that necessity requirement, and then each organization needs to do their own balancing test. Now what's happened is since the implementation of GDPR, many lawyers and data protection officers have created uncertainty by advising companies that consent was safer, even though legitimate interest and consent are equal in the text. In fact, it has been widely come to be believed across society, not just in the context of marketing, that GDPR requires consent even for legitimate local community activities like your local parish, communicating to their parishioners or so on, and that's not what GDPR actually said. And what's the result of that is that growth has been limited at a critical time in economic recovery without providing any additional protection to individuals. So in the bill, what happens is a new amendment that comes in and specifies that any activity that's a legal activity could be a legitimate interest subject to that proportionality, and brings in 3 examples that qualify as legitimate interests, provided you do the balancing test. And the very first one of those mentioned is direct marketing, to give that certainty. Now, actually, all 3 of these examples exist in GDPR. They're actually recitals 47, 48, and 49, and that should have been adequate from a legal point of view. But apparently it wasn't. So effectively, this creates clarity, but without risking adequacy, because the EU version of GDPR already contains those very same recitals and interprets the law in the same way. But an important clarification for marketers in particular. And one thing that's really important is to crucially understand the framework of GDPR, which is that it's risk-based and proportionate. And a very important part of GDPR is Recital 4 that says that privacy is not an absolute right, but is a fundamental right, and must be balanced with other rights, such as the right to conduct a business. So when we look at our conversations with government on the legislation and with the ICO, I think we can all agree that there is nothing more fundamental to the right to conduct a business than finding new customers and retaining your existing customers. In fact, you don't have a business or you don't have a charity without donors and volunteers and so on. So those essential activities are fundamental to the interests of those organizations. That really goes behind the arguments we made. But it's really important to remember and to note that in the legislation, consumer protection is not diminished because individuals always retain an unfettered right to object to marketing at any time by whatever channel. So if people tell you they don't want to hear from you, or they tell you they don't want to receive emails by clicking the unsubscribe, then you have to honor that without doubt. So the essential protections remain. And there are further protections in certain channels, like the mailing preference service and the telephone preference service, that enable consumers to opt out of specific channels. And those are actually both run by the DMA. We're the only business organization with a consumer protection division, if you want to think of it that way, in the UK. So the other big area we worked on is clarifications in PECR for marketers. And we have a lot of charities in membership, very important to charity fundraising. In the current interpretation of PECR, they have not been able to take advantage of the soft opt-in for email, which enables companies to communicate to existing customers or prospects without consent. In other words, on a traditional opt-out basis, provided there is that unsubscribe link in the email. And what this does is it extends the same opportunity to charities and other non-commercial organizations for their fundraising and volunteer relationship management. There are quite a few amendments to the cookie requirements in PECR. So the government's ultimate objection is to eventually get rid of all cookie pop-up banners, but we don't get all the way there in this legislation. But what it does do is it create exemptions for statistical purposes for own use, so all your audience measurements of your website and the traffic flowing across your website, enhancing website functionality, security and software updates, emergency assistance. And the net effect, we think, of these exemptions is that when you're an e-commerce website, for instance, who is not advertiser supported, so if you're a website that is not taking advertising and purely dealing with first-party relationships with prospects and customers visiting your site, or you're a B2B organization who's also not taking advertising and having any third-party identifiers for personalized digital advertising, then you may well be exempt from the requirement of having cookie pop-up banners, and your customers can make their way to your website without that interruption in their journey, which I think we all agree doesn't actually provide any consent at all, because people just click the pop-up banners to get to where they're going without reading anything along the way. So it should create some benefit. And then one thing to note in terms of the balance, it does strengthen the fines in PECR, and particularly applying to nuisance calls, texts, and emails to match GDPR. So this just really toughens up, especially on rogue cold callers and other rogue spammers and breaches, that would enable the ICO to levy fines of up to £17.5 million, whereas it was previously £500,000. So it really matches PECR to GDPR. Another area where there's some change is in the accountability framework. This is part of what the government's emphasizing, is reducing administrative burdens and bureaucracy, especially on small business SMEs. So effectively, there's not big changes because things like data protection officers, data protection impact assessments, and so on are replaced with similar concepts such as senior responsible individuals and assessments of high-risk processing. And our members actually didn't want those changes because they thought it just creates a little bit more confusion when everyone's gotten used to DPOs and impact assessments and so on. But so be it, it's not harmful. The most important change is for smaller companies who do not conduct any high-risk processing. So in other words, they're not third-party data providers, for instance. They will be exempt from all the requirements of keeping records of data processing. And for the very smaller and micro businesses in the country, that should remove a huge amount of administrative burdens. Very quickly, I mentioned this, I won't go too far into this, but the most important change for commercial organizations is it extends the definition of scientific research to include scientific research in commercial settings. So that means your product development, your service innovations, the work you're doing to fill your customer needs with new offers, new services can be covered under scientific purposes, and it makes market research in particular a little bit more easy to conduct to better understand your customers. I will talk a little bit about codes of conduct. So it's not widely known, but in GDPR are Articles 40 and 41, which create the notion of codes of conduct developed by trade associations to interpret how GDPR should apply to the processing that their sector does, with approval and agreement by the ICO. And then in Article 41, it creates industry monitoring bodies. So that complaints against companies that are compliant with the code and have passed an assesstive process, complaints to the ICO will be passed to the industry body to investigate rather than being investigated by the ICO. So creating collaborative regulation on data protection legislation. And as we were going through the process of getting our code of conduct for direct marketing approved by the ICO, their lawyers back in December determined that a GDPR code of conduct could only cover GDPR issues. But really you can't have a code of conduct for direct marketing under that government definition unless you're covering issues around email and telephone and cookies and other things. So one of the big changes in this legislation is to create codes of conduct in PECR that conclude that a PECR code of conduct may be contained in the same document as a GDPR code of conduct. So now we can proceed with getting industry co-regulation for data protection in the sphere of marketing. There's some changes in the objectives for the ICO, and I think basically it's again trying to find that right balance between innovation, growth, and privacy. So it does ask that when the ICO is setting policy to interpret the legislation or going about investigations, they should take into account the desirability of promoting innovation alongside the importance of protecting privacy and the desirability of promoting competition in data and digital-driven markets. And there are some also changes in organization structure because in some kind of a legacy structure, the ICO is a corporation sole, and that means all of the power rests with the individual person of the Information Commissioner, John Edwards, and by changing the corporate structure to match what other UK regulatory body has, it will have a board of directors overseeing an executive and move away. So that's more of a technical evolution. So I will, in my last 5 minutes, talk a little bit about EU adequacy, because that's what our members thought were most important. And you will have some of the privacy, international, Big Brother Watch, open rights groups out there trying to make the case that this legislation undermines adequacy with the EU. And when we looked at it, we took a close look, my legal team led by Jamie Cameron, with every EU Court of Justice ruling on the issue of legitimate interest rate for advertising and marketing dating back to 1995. And in every instance, that European Court of Justice, which, by the way, the Brexiteers don't really like very much, but in any case, that's what made it a good paper to submit to the government. In every case, they ruled that any interest that is legal may be a legitimate interest. They've always ruled that no member state may limit the scope of legitimate interest, and that processing, again, subject to the necessity and subject to the proportionality. And I think there's a very important opinion written by Advocate General Bobek in a case called Fashion ID that actually involved Meta and data at Facebook. But he concluded, again, I would agree that marketing or advertising can as such constitute a legitimate interest. So that firming up of legitimate interest for direct marketing in the legislation is not inconsistent. And beyond that, in our work on codes of conduct, which I've been talking about, we have a code of conduct for third-party data for direct mail that's been approved by the Austrian Data Protection Authority that specifies legitimate interest as the correct basis for third-party data for direct mail, which is a really important precedent. There are similar precedents in Italy. So I think we feel we're on very good grounds. There's evolution in the legislation that will help marketers. And just in conclusion, I just want to remind everyone that ensuring that your teams have the right skills, the right knowledge of their legal and compliance requirements, and the skills to practice at marketers is essentially a core part of GDPR and accountability. And we have a very large, through our institute, the Data and Marketing Institute, skills development program. And one of the new things that we have recently, because our members have told us for the past 2 years that skills development is their biggest challenge, but that budgets for training are very tight. So we've secured funding for the Department for Education to run skills boot camps, skills for life boot camps on what we think are the twin pillars of modern data and digital marketing. So we have a digital marketing strategy program and a data strategy, analytics, and measurement program launching in October. Digital strategy's been going for more than 12 months. Now on that, the government funds 90% of the costs for SMEs and 70% of the costs for corporates. So if you do have people transitioning jobs, if you do have people with legacy marketing skills that they need to update, if you have new employees that have joined your marketing departments, it's a great cost-effective way. It's a great cost-effective way to bring your teams up to date, and they all include modules on data protection and privacy requirements under the law. So there's a half day in each one of those on the legal requirements. So I think we've come in with just 1 or 2 minutes to spare. I can take 1 or 2 questions now, or I can linger around and pick up any questions one-to-one afterwards. I think a microphone is coming.
Oh, there we go. Fantastic, thank you very much, that was really informative. On the question of GDPR versus PECR, there's legitimate interest, the definition of legitimate interest is changing for GDPR. PECI said still requires for advertising purposes the notion of consent, no tracking. Is that right?
To an extent. So GDPR covers all the processing that you would do, and PCR often covers that last notion of sending.
It's access of terminal, isn't it?
So what you're clear on is for your profiling, for your segmentation, for your preparation of the campaign, for the campaign personalization, for all the work you would do until, say, the sending of the email, you can do it on the basis of the legitimate interest. And then so that soft opt-in...
So just to be clear, the capturing of an identifier at the point of entry and access to terminal is allowed under legitimate interest. I don't need to seek the consent.
It should be. You'd have to look at the specific circumstances, but yes, technically, yes, for establishing for advertising. And it does create some opportunities. The thing to remember is that there are always other requirements where consent is necessary. So if you're processing special categories of data, for instance, then you have to use consent. And I should note, by the way, that soft opt-in for email that applies to existing customers is effectively a legitimate interest clause, although the EU has never wanted to accept that it is a legitimate interest basis. But it effectively is an opt-out mechanism similar to legitimate, provided you have the unsubscribe. So it doesn't cover everything. The actual sending of the email would have to either be on the basis of consent or the soft opt-in.
I'm referring more to the ability to do digital marketing, so advertising through Meta, Google, whatever other platform it is, generally requires that when the user arrives, we set an identifier on the user's terminal, which we then transmit to the third parties to enable personalized or directly targeted marketing. At present, that requires consent to access the terminal and do that, whether it's a cookie or storage.
Yes, and that exemption is not one of the cookie exemptions that are in this bill
just
yet.
So you have to still seek consent.
For the placement of the cookies.
Yeah, or any search. Thank you.
But the notion that Facebook could be funded by advertising or that advertisers should find new customers on Facebook could be on the basis of legitimate interest. Okay, I think we probably have to wrap because I think there's a next speaker coming up, but I'll linger around if anyone wants to come up and have a chat.